Hello guys, this is Professor Harsh KACHALIA and welcome back to this new episode of Who Wants to Be a Logician? So, so this is the last episode of Who Wants to Be a Logician, where we are discussing independent MCQs. Again, we are going to come up with a few more episodes, but those won't be in this manner. Those would be MCQs which are case study based. So we will discuss the case study based MCQs also in our upcoming classes, upcoming videos. But here, 96 to 100, let's rock on and hit on the century. All right. So question number 96 coming up on the screen right now. It says Mr. A, Mr. B, and Mr. C are partners. They are partners in a partnership firm. All right. The firm made an agreement. They are saying the firm has made an agreement in writing to refer a dispute between them to the between them and the business to the arbitrator. So A, B, C are partners, and they have decided that any kind of dispute we will take it to the arbitrator. Okay. In spite of the agreement, Mr. B has filed a suit against Mr. A and C. Now, can you do that? Is it allowed? Even if you have an agreement for arbitration, can you go for litigation? So here the question is, you have to examine whether the admission of the suit which is filed by Mr. B against Mr. A and C in the court is acceptable or not in the light of arbitration and conciliation. You've got 4 options on the screen and your time starts now. Time's up. So the answer is yes. Do we have the answer? The answer is no. Not this. Sir, when you have a valid arbitration agreement, in that case, without having the consent of the other parties who are a part of this agreement, sir, how can you even go for litigation, sir? You cannot go for any case of litigation when you have an existing case, existing agreement, a valid agreement under arbitration. Is that clear, everyone? All right. Let's go to 97. 97 on the screen. Here it is. New Era Financial Services Limited is registered with RBI. Okay. It defaulted in the payment of the dues to its catering contractor. Okay. So they have defaulted in the payment of the dues to its catering contractor. Is it possible for the contractor as an operational creditor to initiate insolvency resolution process or not? Yes? No? A, B, C, D? Simple question. Answer is very simple. I can just reveal it right now, but 30 seconds you've got. Time starts now. Dun, 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 dun. Time's up. So guys, yes, no. What do you feel? Is it possible? Answer is no, sir. If it was a default with the catering contractor by anybody else, then yes, we might have said that, okay, you can go and file your complaint, file your application. But in this case, you need to note one thing, and that is what? That is, in this case, the default was by RBI, is what they are saying. That is a financial service limited who is registered with RBI, and the financial service providers are included in the exceptions where you cannot file a case against such persons. Is that clear? Yes. So New Era is a financial service provider who is covered in an exception, so you cannot file this case as an operational creditor. Of course, you can go under the company law and go and start the winding up proceedings, and all those options will be there. But under IBC, my apologies, you are not allowed, and not allowed. Question 98 on the screen. All right. Ruby Petals Limited, it's a small company, filed an application with the NCLT stating that the fast-track corporate insolvency resolution process against it cannot be completed within the prescribed period of 10 days. On being satisfied, NCLT has given an order to extend the process by 30 days. 90 days cannot be completed. They have given an extension of 30 days. It is the case of fast track insolvency. Fast track insolvency, how much is the period? 90 plus maximum to 45. Here it is 90 plus 30. However, Ruby Petals Limited again initiates an application for further extension of 10. That goes to 30 plus 10, 40. Which of the following option is applicable? Extension can be only once, or extension can be more than once. Extension can be up to 30 days only, or 45. And 45 is the answer I already told you. You have to determine whether it is a one-time extension or up to 45 days as maximum extension. You can take it any number of times. The choice is yours. Your 30 seconds start. So the answer is, can the extension be given? No, sir. Extension cannot be given, can absolutely not be given. The reason is very, very simple, sir. Extension can be given up to 45 days only under fast track insolvency resolution process. But when you say 45 days, what you need to understand over here is, it can be any number of days up to 45 days. You can give 10 days, 15 days, 20 days, 30 days, 35 days, 40 days, 45 days. Any number of days, but once. But just once. Extension cannot be given more than once. Is that clear? Yes or no? Lovely. Let's go to 99. MX Limited was admitted in the CIR under section 7. 7 means financial creditor, alright, of the Insolvency Bankruptcy Code. The resolution professional of MX Limited was a corporate debtor. The resolution professional of MX Limited, MX Limited is a corporate debtor, conducted the COC meeting, that is Committee of Creditors meeting. But the same meeting was adjourned due to the lack of quorum. Sir, Companies Act, when the meeting is adjourned due to the lack of quorum, it is adjourned up to next week, same day, same time, same place. If it is a national holiday, then next working day is what we say. Here they have said under Insolvency Bankruptcy Code, the meeting has been adjourned. Okay. Accordingly, in the adjourned meeting, the resolution was passed by the COC, that is Committee of Creditors, representing 51% of the voting rights for the liquidation of the corporate. Before the expiry of CIRP, okay, you are a qualified chartered accountant in the team, and you are required to advise RP whether the resolution of liquidation which was passed in the adjourned meeting, is it valid or is it not? To answer this question, you should first know What is the quorum required in the meeting of COC? If the meeting is adjourned, then what is the provision for the adjourned meeting of the COC? Very important provision. Of course, it is there in our notes, basic small summary notes also it is there. Everything is available over there. Choice is yours. Find out the correct option. Right? ABCD, 4 options, 30 seconds, starts. Come on, guys, tell me. The correct answer is invalid. Of course, it will be invalid, sir. Insolvency and bankruptcy code, sir. Meeting of the COC, sir. Requirement over here is 66% votes. And in the given case, how much voting has been done? It is 51% votes. And 51% definitely is less than 66%. And hence, this resolution will not be considered as passed. Yes or no? All right then. Lovely, fantastic, super mind blowing, my dear friends. Let's go on to the last MCQ. That is MCQ number 1. Not. Shivdeep submitted his claim as an operational creditor to the liquidator of Chiranjeevi Food Products Limited, who is a company under liquidation. If Shivdeep wants to alter his claim, state the time period within which he can alter. Very simple provision. Very simple. For one line answer is there in our notes. Yes. I don't want to say anything more, otherwise I'll just straight away reveal the answer only. 30 seconds starts now. Come tell us the right answer. It is pudding. Absolutely no prizes for guessing, one of the easiest of the lot. And with this, our episode of Who Wants to Be a Logician comes to an end. I hope that with these 100 MCQs, all of you might have qualified as logicians. And remember me, when your success, do let me know when you succeed. I will be very happy to celebrate your success with you. Do let me know if your success gets delayed for any reason. I'll be very happy to help you to go and get your success as near and as fast as possible for you. All right. This is KACHALIA signing off over here. Took all the possible efforts to help you solve the MCQs episode wise with conceptual clarity. I hope that I have succeeded to an extent at least. And yes, I will be coming up with more videos for all of you on different platforms in different ways. Try to keep in touch. You need videos, you need notes, you need PDFs, you need question bank, you need summary book, anything you need, you know how to find me. I'm there on Facebook, I'm there on Instagram. You can find me anywhere if you don't have my number. And I'll be very happy to help you. All right. Until then, thank you very much. God bless you all. Cheers and blessed be all of you. Thank you.